I'm a registered migration agent in Australia. So today we'll talk about a thing which is a little bit complex. It's bogus documents and false or misleading information. Can result in visa refusals in some very complex cases, and sometimes it's very difficult to win. Okay, so I'll try to be brief. What's a bogus document? So a bogus document is, as the law says, a document that has in fact not been issued in respect of a person. So you never worked there, you just did the work reference yourself. They call up the employer or they check the employer records. Seems that the work reference has never been issued in respect with you, or the employer confirms that it hasn't, or there is no taxation to back up the fact that it has been issued, in fact, that you in fact worked there, then it becomes a bogus document. Or a bogus document, another option, as the law says, is counterfeit, which means not real, or has been altered by a person who does not have the authority to do so. So, for example, you did work somewhere, and you were issued a reference, but you altered it. Someone else altered it, changed the dates of employment because you needed more work experience. So you just went on. Not many people do it like this today. So most people would use graphic designer, web software, whatever, to change the dates, get a lot of work experience. And that means you altered the document, but you had no authority to do so. You're not the employer. You could not have altered the documents. And the third option is the document was obtained because of a false or misleading statement, whether made knowingly or unwittingly. So you can't say, I didn't know. No, you can't say that. It's bogus, regardless if you knew or not. You obtained it as a result of a false or misleading statement. So, for example, you went to a skills assessment authority, the Trades Recognition Australia, just as an example, and you obtained a skills assessment. To get that skills assessment, you lodged bogus payslips or bogus taxation reports or bogus super reports or whatever. And you think the skills assessment outcome that you got is not a bogus because it was officially issued by the skills assessment authority, right? Well, no, it's bogus. Because it was issued as a result of a false statement or other false documents that you supplied to the skills assessment authority. That's bogus documents. Now, what is false or misleading information? False or misleading information can be different, and there are actually many ways to provide false or misleading information. So let me give you some typical examples. You apply for a visitor visa or any other visa, and the question is, have you applied and been refused the visa to any other country? Has your visa to any other country been cancelled? Have you overstayed? And you say, no. Whether knowingly or unknowingly, even if you forgot, even if you didn't remember, if it was in fact refused or cancelled, you should have put yes and explained why. Putting no can lead to a refusal for provision of bogus, false or misleading information. Well, let me give another example. What they absolutely love is partner visas. They absolutely love partner visas. All the tribunal, 50% of the tribunal workload for big 40-20 bogus documents, false or misleading information are for partner visas. And where they say, well, you said yes, that you have a genuine commitment to live together to the exclusion of all others, blah, 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 blah. But it seems on the fact that the sponsor who sponsored you was made to do so because the sponsor was intoxicated or under the influence of drugs, or there is evidence you started living together and then married on the same day, on the next day, or in 2 days, and it seems that the sponsor, there was no genuine relationship between you two. Although you claimed, you said, yes, the genuine relationship existed. This is how they try to crack a lot of these sham marriages, a lot of these non-genuine relationships, right? Where other examples can be a question about criminal convictions. Do you have any? And you say, no, of course not. And have you ever been charged? Oh, no, of course not, although you were. That's also an example. Big 40-20. There are many other questions that they can ask you. You can say no. Just to be eligible for a visa, because you would be afraid that it's part of the assessment of the visa. And if you say yes, you might not meet the requirements for a visa, and you say no instead. And this is where they catch you if you are untruthful. So that's also misleading information. Okay. Now, what are the cases worth fighting for? When there is misunderstanding by the decision maker of your case scenario, when they didn't understand your responses because of some cultural thing, or in fact you didn't provide a bogus document. It was not bogus, it's just that they do not understand how documents are issued in your country. And sometimes they get a verification check, but a verification check gives them rubbish information, which is not true either. So, and what you have provided is in fact true, and then we can fight for it. Or we can fight for it, for example, if you had another agent, and it's a very popular scenario, you had an agent who is not a registered migration agent, not a lawyer, just someone from your home country with no qualifications, no registration, no responsibility for whatever, and they provided the bogus document, okay? They provided, for example, bogus bank statements for a student visa. That happens a lot of the time. Bogus bank statements for a student visa. A lot of the cases are about that. But when we fight this, we have to prove that the bogus bank statements provided, you were not complicit in the provision of those statements. You were not part of that. Which means I would ideally want to see a written correspondence between you and your agent where you advise, these are the normal proper bank statements. This is what I have. Please supply this. And they supplied something else because they wanted to improve your application themselves. So they did harm to your application by lying, and you were not part of that lying, and communication between you and them supports the idea that you were not part of the lying, okay? Not part of the deception, not part of deception. Also, we can try to, in cases where there is no purposeful falsity. The case of Trivedi has identified that it is the purposeful falsity that the department and the tribunal are trying to capture. If that did not have the quality of the purposeful falsity, it was just an innocent mistake. Getting one number wrong on the birth certificate when you type the number of the birth certificate, or doing something which is not guilty, something entirely accidental, we can argue that it's not purposeful falsity, not to meet the requirement, not to deceive, no intention to deceive. Okay, that's where we can meet. So a lot of complexity with this, as you can see. I would be happy to help. Please use the link below to book a consultation with me, and we will talk about your case. We'll talk about your scenario, whether the department is considering refusing you, whether the department has already refused you, or whether this has gone to the tribunal already. I will be able to help and give advice on this matter. So please reach out. And we'll try to do something for you. See ya.